Welcome back to SCOTUS Oral Arguments and Opinions. As of the time of recording, today, June 26th, 2025, the Supreme Court released 4 opinions. We'll work through each. This episode will focus on the case called Hewitt versus United States, case number 23-1002. This case was consolidated with Duffey versus United States, case number 23-1007. Please note that this summary is read by an automated voice. In this case, the Supreme Court ruled 5-4 that defendants whose sentences have been vacated can benefit from the First Step Act's more lenient penalties when they're resentenced, even if they were originally sentenced before the act became law. The case centered on whether a vacated sentence counts as having been imposed under the act's retroactivity provision. Justice Jackson's majority opinion held that the present perfect tense has been imposed requires the sentence to still be legally valid, not just a historical fact. The decision means that defendants like the petitioners, bank robbers who faced over 100 years under the old mandatory stacking regime, can receive significantly reduced sentences under the First Step Act's reforms. In this episode, we'll examine the competing interpretations in Justice Jackson's majority opinion against Justice Alito's dissent, which argued the court was rewriting the statute to advance sentencing reform rather than interpreting Congress's actual words. Then we'll analyze the judicial dynamics where Chief Justice Roberts and Justice Gorsuch joined the core holding, but refused to sign onto Jackson's policy-heavy reasoning about legislative history. Finally, we'll consider the practical implications for federal sentencing and future criminal justice legislation. The question presented in this case is whether the First Step Act's sentencing reduction provisions apply to a defendant originally sentenced before the FSA's enactment when that original sentence is judicially vacated and the defendant is resentenced to a new term of imprisonment after the FSA's enactment. Justice Jackson delivered the opinion of the court with respect to Parts 1, 2, and 3, in which Chief Justice Roberts and Justices Sotomayor, Kagan, and Gorsuch joined, and an opinion with respect to Parts 4 and V, in which Justices Sotomayor and Kagan joined. Justice Alito filed a dissenting opinion, in which Justices Thomas, Kavanaugh, and Barrett joined.
Justice Jackson's majority opinion. Before the First Step Act was enacted in 2018, federal judges were required to sentence first-time offenders convicted of violating 18 U.S.C. Section 924C, a law that criminalizes possessing a firearm while committing other crimes, to stacked 25-year periods of incarceration. The First Step Act eliminated this harsh mandatory minimum penalty. Section 403B of the Act also made its more lenient penalties partially retroactive. Specifically, if a sentence has not been imposed upon an eligible Section 924C offender as of the date of the First Step Act's enactment, the Act applies. The question presented here concerns an edge case. What penalties apply when a Section 924C offender had been sentenced as of the Act's enactment, but that sentence was subsequently vacated, such that the offender must face a post-act resentencing? In 2009, petitioners Tony Hewitt, Corey Duffey, and Jarvis Ross were convicted of multiple counts of bank robbery and conspiracy to commit bank robbery, along with corresponding Section 924C offenses for use of a firearm during a crime of violence. Each petitioner received a mandatory 5-year sentence for his first Section 924C count of conviction, and, despite being first-time offenders, each received 25-year mandatory sentences on every Section 924C count beyond his first. Thus, each petitioner's sentence exceeded 325 years. Petitioners successfully challenged some of their convictions on direct appeal, and the Fifth Circuit vacated petitioners' sentences. In 2012, the district court resentenced each petitioner to between 285 and 305 years on the counts that remained. In 2019, the court held that the crime of violence definition the government routinely used to support some Section 924C convictions was unconstitutionally vague. Because that holding potentially affected some of petitioners' remaining convictions, the Fifth Circuit granted petitioners authorization to file a second or successive post-conviction motion. The district court then vacated the impacted Section 924C convictions, as well as petitioners' sentences. When the district court held resentencings for the remaining convictions, petitioners argued that the First Step Act's 5-year, not 25-year, mandatory minimum penalties applied. Petitioners argued they were entitled to retroactive application of the Act's more lenient penalties because a vacated prior sentence is not a sentence that hasn't been imposed for purposes of Section 403B. The district court disagreed and resentenced petitioners under the pre-act sentencing scheme, giving them stacked 25-year mandatory minimums for each Section 924C count of conviction beyond their first. Petitioners thus each received sentences of 130 years or more. On appeal, petitioners and the government agreed that the First Step Act should have applied at petitioners' resentencings. The Fifth Circuit denied their joint request for vacatur. In that court's view, Section 403B applies only to defendants for whom a sentence had not been imposed as of the enactment date. Because each petitioner had been sentenced twice prior to the Act's enactment, the panel concluded that petitioners were not eligible for the First Step Act's more lenient mandatory minimums. Held under Section 403B of the First Step Act, a sentence has been imposed for purposes of that provision if and only if the sentence is extant, i.e., has not been vacated. Thus, the Act's more lenient penalties apply to defendants whose previous Section 924C sentences have been vacated and who need to be resentenced following the Act's enactment. The text of Section 403B and the nature of vacatur support this conclusion. Congress employed the present perfect tense, requiring evaluation of whether a sentence has been imposed upon the defendant rather than the past perfect tense that would exclude anyone upon whom a sentence had been imposed. The present perfect tense can refer to an act, state, or condition that is now completed, or a past action that comes up to and touches the present, and thus conveys that the event in question continues to be true or valid. When used in either sense, the present perfect tense addresses whether something has continuing relevance to the present, not merely whether it occurred as a historical fact. If an event is merely a relic of history because it was voided by a subsequent action, the past perfect, not the present perfect tense, is usually the more appropriate verb choice. The fact that adjacent provisions of Section 403 contain past tense verbs only strengthens the conclusion that Section 403B's use of the present perfect tense is meaningful. B. Background principles regarding the legal effect of vacatur confirm that a sentence has been imposed for Section 403B purposes only so long as it remains valid. When interpreting statutes, the court recognizes that Congress legislates against the backdrop of certain unexpressed presumptions. One such presumption is that vacated court orders are void ab initio and thus lack any prospective legal effect. A criminal defendant whose conviction has been vacated, for example, is to be treated going forward as though he were never convicted. By operation of legal fiction, the law acts as though the previous conviction never occurred. Section 403B reflects this common sense understanding of background vacatur principles. Just as defendants with vacated prior felony convictions are not precluded from possessing weapons under the federal felon in possession ban, Section 403B, retroactivity does not exclude from its scope those whose prior sentences were vacated. By authorizing retroactive application of the First Step Act's more lenient penalties on any eligible offender upon whom a sentence has not been imposed, the text of Section 403B indicates that only past sentences with continued validity preclude application of the Act's new penalties. Reversed and remanded.
Justice Alito's dissenting opinion. In the First Step Act of 2018, Congress reduced the mandatory minimum sentence for certain firearm offenses. Like all changes to sentencing law, this amendment applies prospectively, but Congress also thought it wise to apply the amendment to pending cases. Of course, pending cases does not mean all cases, and Congress limited the retroactive reach of the amendment to defendants for whom a sentence for the offense has not been imposed as of the Act's date of enactment. 132 Stat. 5222. In other words, the amendment applies retroactively only if the defendant had yet to be sentenced when Congress passed the Act in 2018. Petitioners who were sentenced in 2010 do not come close to meeting that test. Today, the court disfigures the act in order to reach a different result. Its interpretation relies on two necessary premises. First, the court insists that what Congress really meant to say is that the amendment applies retroactively unless a legally valid sentence is in force on the act's date of enactment. Second, to get around the fact that petitioners did have legally valid sentences when the act was passed, the court invents a novel vacatur principle. The court tells us that the 2022 vacatur of petitioners' sentences rendered those sentences legal nullities from their inception. The court's interpretation thus unspools the act's carefully wound retroactivity command to mean that any defendant whose sentence is vacated at any time and for any reason may claim the benefit of the act's reduced mandatory minimum. But nothing in the text or broader context supports such a boundless interpretation. Indeed, the portions of today's decision that command the votes of only 3 justices give the game away. Animating the court's textual interpretation is a thinly veiled desire to march in the parade of sentencing reform. But our role is to interpret the statute before us, not overhaul criminal sentencing. 16 years ago, a jury convicted petitioners Corey Duffey, Tony Hewitt, and Jarvis Ross of multiple 18 U.S.C. Section 924 CE offenses for use of a firearm in furtherance of a crime of violence. At the time, first-time paragraph 924 C offenders like petitioners could receive, after a single trial, a 5-year mandatory minimum sentence for an initial paragraph 924 C conviction and a consecutive 25-year mandatory minimum sentence for each second or subsequent paragraph 924 C conviction. Petitioners' sentences had thus long been final when Congress enacted the First Step Act on December 21, 2018. The act introduced a bevy of sentencing reforms, including an amendment that eliminated the practice of Section 924C sentence stacking. See 132 statutes, 5221-5222. Although it had previously considered applying this amendment to all Section 924 CE offenders, including those with final sentences, CS 2123, 114th Congress, First Session, Section 104B2, 2015, reported by committee, Congress settled on a far narrower retroactivity command, applicability to pending cases. This section, and the amendments made by this section, shall apply to any offense that was committed before the date of enactment of this act, if a sentence for the offense has not been imposed as of such date of enactment. 132 Stat. 5222. On the date of enactment, petitioners' 2012 sentences remained in full force. As such, petitioners did not move to reduce their sentences in the immediate aftermath of the Act's passage. But several strokes of good fortune soon came petitioners' way. The year after Congress passed the First Step Act, we held in United States v. Davis that Section 924C's residual clause is unconstitutionally vague. Then, later that same year, the Fifth Circuit determined that Davis should apply retroactively. Seeking to take advantage of these fortuitous developments, petitioners successfully moved to set aside some, though not all, of their Section 924C convictions that were predicated on the residual clause. Although the district court could have vacated petitioners' sentences for only those invalid Section 924C counts, petitioners caught yet another lucky break. The district court opted to vacate their entire sentences and ordered plenary resentencing on the remaining counts. Petitioners now try to push their luck even further, contending that the district court should apply the First Step Act's reduced mandatory minimum for their remaining Section 924C counts. As all agree, petitioners' argument requires us to interpret what Congress meant when it said a sentence for the offense has not been imposed as of the Act's date of enactment. What first jumps out about this provision is that Congress used the present perfect tense in the phrase, has not been imposed. The present perfect tense denotes an act, state, or condition that is either 1, now completed, or 2, continues up to the present. The Chicago Manual of Style, Section 5.132, page 268, 17th edition, 2017. Context often indicates whether a speaker is using the former sense of the present perfect tense, e.g., he has been awarded a trophy, or the latter sense of the present perfect tense, e.g., he is trained for a trophy for the last 3 years. Consider the following example. Suppose I ask a man passing by a courthouse, has a sentence been imposed on John Smith? He could respond either, yes, on July 1st, or yes, since July 1st. The former response is perhaps the more natural one, and it assumes I asked for the historical fact of Smith's sentencing in the indefinite past. The latter response is correct, though perhaps awkward, and it assumes I asked about the continuing legal validity of Smith's sentence up to the present. The First Step Act's grammatical structure conceivably leaves some room for either reading, but petitioners lose either way. On one hand, the phrase, a sentence dot, has been imposed as of the Act's date of enactment could refer to the historical fact that a district court imposed a sentence before the Act's passage, regardless of whether that sentence remains legally valid in the future. This historical fact interpretation plainly forecloses relief for petitioners because, as no one disputes, the district court first imposed their sentences well before the Act's passage. On the other hand, a sentence dot has been imposed as of the Act's date of enactment could mean that a defendant was subject to a legally valid sentence that continued to be in force on the Act's enactment date. But again, petitioners did have legally valid sentences as of the Act's date of enactment, so they lose under this legal validity interpretation of the Act too. The most plausible reading of the retroactivity provision is that a sentence has been imposed when, as a matter of historical fact, a district court has sentenced a defendant. Subsequent legal changes, such as the vacatur of a previously imposed sentence, do not change the purely historical fact that a defendant was, at a point in time, actually sentenced. A sentence is imposed when there is a pronouncement of judgment. The word imposed is thus most naturally understood to refer to a concrete action by a district court that occurs at a specific point in time. The court's vacatur principle does not exist. The court assures us that there is a well-established principle in the criminal law that vacated court orders are void ab initio and thus lack any prospective legal effect. But a more careful reading of our precedents and other provisions in Title 18 indicates that vacatur does not erase the historical fact of a previously imposed conviction or sentence. The retroactivity provision's title, Applicability to Pending Cases, advises against the court's boundless interpretation. The phrase pending cases suggests Congress was concerned with the finite population of defendants who, on the date of the First Step Act's enactment, lacked an initial sentence for Section 924C offenses. But the court's vacatur principle would obliterate that closed set and refashion the retroactivity provision as an open-ended entitlement for any defendant convicted of multiple Section 924C offenses whose sentence is vacated at any time and for any reason. The presumption against retroactivity further weighs against the court's unnecessarily broad interpretation. Congress may give retroactive effect to new reductions in criminal penalties, but it must do so with plain import or fair implication. To the extent there is any ambiguity about how far the Act's retroactivity command should go, the presumption puts a thumb on the scale against construing the retroactivity command to its broadest extent, as the court does today. In 2019, we decided Davis and provided a basis to set aside petitioners' Section 924C convictions under the residual clause. But Davis did nothing to disturb petitioners' other Section 924C convictions and associated mandatory minimum sentences. In cases involving multi-count indictments and a successful attack by a defendant on some but not all of the counts of conviction, a court, in such instances, may vacate the entire sentence on all counts and reconfigure the sentencing plan in toto. Green Law, 554 U.S. at 253, emphasis added. But As petitioners' counsel conceded, courts are under no obligation to follow this convention and may instead choose to vacate only those parts of the sentence related to an intervening change in law. Traverse of oral argument 15. Nor does this strike me as a case in which full vacatur was warranted. Section 924C convictions must run consecutively with any other term of imprisonment. Section 924, subsection C, subsection 1, subsection D, subsection 2. So Section 924C sentences are presumably easier to identify and extract from a defendant's total term of imprisonment, often obviating the need for a plenary resentencing. The likely unnecessary vacatur of each petitioner's entire sentence was thus a stroke of good fortune that opened the door to petitioner's First Step Act claims. The lower courts, correctly, rejected those efforts, but petitioners have found a sympathetic audience in this court. The three justices attribute today's outcome to grand congressional design coming to fruition, but in reality, petitioners' change in fortune can be attributed only to the happenstance of legal developments, with not the faintest relationship to the First Step Act. The court ignores Congress's intention to afford only limited retroactive relief to certain offenders under the First Step Act. Instead, the court embraces an interpretation that has no limiting principle and affords petitioners a windfall. That is an indefensible result based on indefensible reasoning. I cannot agree with the court's decision, so I must respectfully dissent.
Those were the majority and dissenting opinions. Now, let's discuss Part 4 and 5 of the opinion, the portions where Chief Justice Roberts and Justice Gorsuch departed from the majority. While Justice Jackson secured 5 votes for the core legal holding in Parts 1, 2, and 3, she could only muster 3 votes, her own, Justice Sotomayor's, and Justice Kagan's, for Parts 4 and 5 of her opinion. Chief Justice Roberts and Justice Gorsuch, who had joined the earlier sections, chose not to sign on to these parts. What did Jackson write in these sections that lost those 2 conservative votes? Parts 4 and 5 dive deep into the legislative history and policy arguments behind the First Step Act, territory that apparently made Chief Justice Roberts and Justice Gorsuch uncomfortable. In Part 4, Jackson chronicles the sustained criticism that led Congress to act. She quotes federal judges who called the old stacking regime grossly disproportionate and shockingly harsh. One district judge lamented giving what he called the worst and most unconscionable sentence in his 23 years on the federal bench to a 22-year-old first-time offender facing 40 years. Appeals court judges joined this litany of criticisms, describing the mandatory sentences as out of this world. Jackson doesn't stop with judicial criticism. She notes that the U.S. Sentencing Commission condemned the stacking practice as producing excessively severe and unjust sentences, particularly when no physical harm occurred. The Judicial Conference expressed similar concerns. This all culminated, Jackson writes, in an extraordinary political coalition, forming around bipartisan sentencing and prison reform. Part 5 then applies this legislative context to bolster her textual interpretation. Jackson argues that her reading reflects Congress's intent better than the dissent's approach, which would create what she calls an illogical further line of division among defendants awaiting sentencing. She contends that requiring judges to return to the old deal-era stacked sentences at resentencing would run headlong into the animating aims of the First Step Act. Now, here's the crucial point. While this reasoning didn't command a majority, it doesn't diminish the binding force of the court's actual holding. 5 justices, a clear majority, agreed that when a sentence has been vacated, it hasn't been imposed for purposes of the First Step Act's retroactivity provision. That's the law. And here's what's equally telling. While Chief Justice Roberts and Justice Gorsuch declined to join Jackson's policy-heavy reasoning in Parts 4 and 5, they also chose not to join Justice Alito's dissent, which directly countered this very reasoning. Alito specifically criticized the majority for wanting to march in the parade of sentencing reform, rather than simply interpreting the statute. Yet Roberts and Gorsuch remained silent on this critique, neither endorsing Jackson's legislative history analysis nor embracing Alito's textualist pushback against it. The fact that Roberts and Gorsuch declined to join the policy-heavy sections likely reflects their judicial philosophy favoring textual analysis over legislative history and policy arguments. But their agreement with the core legal reasoning and holding, and their refusal to join the dissent's criticism of Jackson's approach, suggests they found the textual analysis in parts 1 through 3 sufficiently compelling on its own. That's what matters for courts applying this decision going forward. I'd like to briefly offer a couple of case implications. The immediate impact of this decision will likely be felt in federal district courts handling resentencing proceedings where defendants have had their original sentences vacated for various reasons. Courts will now apply the First Step Act's more lenient mandatory minimums to these cases, potentially reducing sentences by decades for defendants who were originally sentenced under the harsh stacking regime. However, the scope of this relief remains somewhat narrow. It only applies to defendants who actually need resentencing after their sentences have been vacated, not to those with final sentences still in effect. The decision also creates a framework for analyzing similar retroactivity questions that may arise with future sentencing reforms, though each statute's specific language will matter significantly. Looking ahead, this ruling may influence how Congress drafts retroactivity provisions in future criminal justice legislation, now that the court has clarified how it interprets the present perfect tense in this context. Defense attorneys will certainly scrutinize their clients' cases more carefully for opportunities to challenge sentences that might be subject to vacatur, knowing that successful challenges could open the door to First Step Act relief. But it's worth noting that the decision doesn't expand the grounds for vacating sentences in the first place. It simply clarifies what happens when sentences are validly vacated for other reasons. The broader criminal justice implications will depend largely on how frequently sentences continue to be vacated and whether Congress chooses to enact additional sentencing reforms with their own retroactivity provisions. Thanks for listening to this episode. I'll be back soon with more Supreme Court analysis. If you found this valuable, please subscribe and share with anyone who wants to understand how the court really shapes our lives. Up next, Medina versus Planned Parenthood South Atlantic. Talk to you soon.